Welcome to the new episode of the Export Insights podcast, together with me, Vasko Kangilevski. And today we have a special guest, Katerina Smiljkovic, who is a intellectual property law and consulting firm. She's leading one dedicated to helping innovators transform creativity into competitive advantage. And this intellectual property topic has been all around exports, all around innovation, all around investments. So we have her today to help us clarify and give us good information on how intellectual property can help you with your international growth and exports. So, Katerina, welcome to the Exports Insight podcast.
Thank you, Vaska. It's my pleasure to speak with you today.
Yeah. So let's start from the beginning, because we have all these topics about intellectual property and we hear it all around in different perspectives. So maybe just for a start, can you break down what it is comprised of in a business sense? Because we talk about trademarks, patents, copyright, digital rights, all these different types of rights. So maybe give us a framework. I know that many might know, but I'm sure that many SME owners and managers do not know the difference between all these aspects. So if you can please give us a perspective of what we are talking about as intellectual property and what are the core differences between the areas of intellectual property.
Well, we usually speak about intellectual property as one broader concept of intangible assets. There are some rights that we call hard IP rights, which are the patents, the trademarks, and the industrial design. And then we have soft IP, such as copyrights. Then we have trade secrets, know-how, and any type of intangible asset that a company has and that actually brings a value to the company. What each asset actually protects: trademarks protect the name, the logo, the brand, and actually help in the process of building the reputation. Patents, on the other hand, protect the technology inside. For example, how one product works, which is not visible from the outside, but can be crucial for an efficiency of a certain product. Industrial design protects the shape and the look of a product. And it is also very important when we speak about manufacturing and exports. We usually think about physical goods that export, go from one country to another country, which usually are tangible and have a shape. So industrial design can be also a very important IP right in this sense. Industrial design protects the novelty of the design and its individual character. For example, let's say a shape of a bottle. If we take the label of 3 different bottles, if you look only on the shape, you will immediately recognize what is the brand. So that's one of the values that a shape can have. So these are hard IP rights. Why we call them like that? In order to have an IP protection, you need to register them. So file an application, then go through a process, and then an office decides if they reject or if they grant an IP right for you. But other than that, there are also a lot of IP rights that one company has, a lot of intellectual property, like a know-how specific for manufacturing. Sometimes patents protect the product or certain aspects from a product, but if you don't know the know-how, how to produce it, you may not be able to have the same product only if you see the patents. So when we speak about IP, it's actually one layered protection strategy. Each IP right has a different purpose and protects a different part of a product. And the best strategy is when you combine all of them. What is important is that each IP asset needs to have a business goal. You don't protect a product just for the sake of protecting the product and for having an IP asset. Each asset serves certain business goal. And that's why it's very important when we speak about IP and IP strategy, we cannot speak about IP strategy isolated from the whole business strategy. It's very connected to it. Apart from serving its defensive work, if someone tries to copy you, you can defend yourself. You can also be proactive with IP. For example, license your IP, define new revenue streams when you have protected IP, and many different things. So we do have a lot of IP rights. Each of them has a different purpose, and all of them are in certain way important when you decide to export your product outside of the country.
Thank you, Katerina. Now, you mentioned something like every IP has its layered, it has a business purpose. So maybe let's put how crucial and is intellectual property and what we do or the intellectual property strategy with the business strategy. So like, for example, let's take an example. If you're a manufacturing company from the Balkans, we want to export in Europe or globally, what would be the key elements we should consider, or the first steps to consider, maybe to how to connect the intellectual property with the business strategy?
The first question a company should ask is, what is their unique value proposition? When we do an IP framework, we always start from this point. And when we decide with the company what is their unique value proposition, we start protecting from there, but not from the perspective of what an owner thinks that their UPV is, but what the customers are paying for. So when we decide of what the uniqueness is, we always start building the strategy for protection around their uniqueness. IP is different in different industries, Vasco. For example, if we have R&D heavy industries, pharmaceutical companies, many manufacturing companies, when you invest a lot of money in R&D, then you want to have a certain return of that investment. And if you don't protect your IP and you get out on the market, eventually someone will try to copy you, especially if you're good. And if there are customers that are willing to pay for it. When you have IP, you have a protective fence. So it is very important. You don't need to fight on lowering prices with competitors. When you have something unique, you can offer it on a premium price because you have features that are only available to you. Why we think only when the question was how to connect this with export. IP is a territorial right. If you protect IP in your own country, it doesn't mean that it's automatically protected all over the world. You have to think in terms of where you produce, where you sell, and where you partner. And you need to define these territories as part of your export strategy and think in terms of IP. So before even going to that market, the companies should definitely do a clearance search to see if someone else maybe has protected certain IP rights on that territory, and if there is a possibility that they, with their product, infringe others' IP right. Then they should proactively protect their IP right on these territories in order to have a free way there to sell without being afraid if someone copies them. That's also part of this process. And it is also very important when we speak about manufacturing. When we sell digital products is one thing, but when we have a physical goods, companies usually have contracts with distributors, contract with sellers in other countries. They even have contracts with different factories in other countries. So in order to have this chain functional, they need to expose certain part of their know-how, and they should be very careful how to protect this.
So thank you for this. I mean, I will go on the software and on the digital rights, but practically, like before a company goes shipping their first product overseas, let's say, what are the 3 essential steps that you propose a company should take that their brand is not blocked or stolen in the foreign market? And I'm asking about the brand one, and maybe you can add on the product and...
Well, first of all, protect their own IP, protect their own trademark, since we're speaking about brand at this point. Clearance search to see if someone else has protected something that we could get in a conflict tomorrow, and decide strategically on territories. IP also has a limited budget, and it's not advisable always to protect everywhere, but to strategically choose on the territories where to go. There is very interesting example, maybe you have heard of it, about the story of Burger King. It's a well-known world franchise, but in 1971, when they entered the market in Australia, the name Burger King was already taken by a local store there. And even now, Burger King is not Burger King in Australia. They're called Hungry Jack. What they did at that point in time, even though they were an established brand, they were not allowed to use their own name in Australia. Even though they were big, this was some small local company that protected the name early on. So in that case, when you don't do a clearance search and you don't protect everything proactively, what they actually need to do, spend a lot of money on rebranding only for that one country.
What is the trademark protection so important for, or critical intellectual property for companies doing exports? I mean, you mentioned the Burger King, but let's put it in a more practical for a smaller company, for example. What if they don't have their trademark protected and they go into another country? Are there any risks, or what are the risks for the brand and the conflicts? And Are there any legal implications they could have if they didn't check that?
Yes, there are. When we speak about trademark, the trademark usually protects the name of the company. And if you invest in building the brand, you invest in building this name. And eventually a company would want someday the customers to recognize them by their name. And when you say their name, it should signal a certain level of quality. And actually, the trademark signals where these goods come from, the origin of the goods. What is the legal implication? This is also closely related, the registration of a trademark with their domain. And it is very important, even before going out on the market, to make a clearance search. There are specialized databases where we can look for and see what is registered, what everything is registered in that country, in that jurisdiction, in those regions. And even we advise companies how to make a slight change in the name or in the trademark to be distinctive. Because the goal of the trademark is to make a distinctiveness for a company. If you don't have a trademark there, basically anyone can copy you. And the worst thing that can happen is that someone else registers your name in that country, and then you are not allowed to use your own name. So that's why these things are done proactively. We usually say that IP protection after going global is damage control. IP protection before going global is strategy.
This is a great one. So before is later is damage strategy, before is, how did you put it? Well, let's
When you
move
go
to
on the market, you have no idea what you expect to receive back on the market if you don't do your things beforehand.
Do you offer such services for clearance search, or do you have a network that I don't know, some company can turn to you if they want to go to a new market to check the trademarks and the patents?
Yes, we do. We do that before registering any trademark. Okay. And as a result of that analysis, we advise companies sometimes how to change slightly to be more distinctive and to avoid such issues in the future.
I was thinking now, we were talking about trademark, but maybe is there a difference if there is a protection of an invention, so or what the company has at home, protecting it versus abroad? And is there a case, and what would happen if a company unknowingly exports a product that is patented by someone else in the other country they are exporting?
Yes, there is a patent. When we speak about patents, patents protect technical inventions, technical parts. So how a product actually works inside something that is not visible to the eye. There is a very slight line between patents and trade secrets sometimes. But if I put the product on the market and then someone can buy the product and reverse engineer it, then it is always better to protect it by patent, because patents are public disclosure. What is a patent actually? It's a contract between the inventor and the country. So the inventor says, okay, I agree to disclose my invention to the public for the sake of technological advancement. And then the country says, okay, we will grant you monopoly for 20 years. When you go outside and you have protected patent only in your country, you're not protected outside of your country. So there are systems how to extend this protection outside of the country, and companies should always think in terms of where they sell, where they produce, and where they partner. So these three regions should be always covered with protection. On the other hand, if you do that, you will be protected in all of these regions and you won't have an issue. But on the other hand, if you go on a market, you at the same time, you don't know what is protected there beforehand from other companies, what your competitors have, because they're also active in the patenting field. That's why they also need to do a freedom to operate search. Are you free to sell your product in that market? Or maybe someone before that has protected their IP there. And if you go and freely sell your product unaware of others' IP, you could get in trouble. And these patent battles are pretty big, expensive, and that's why it's always advisable to make a freedom to operate search.
Before I go to the next questions, many, smaller companies that are manufacturing, that have their own inventions, often say like the patent takes a lot of time. We might risk it and go to a specific country, and while the patent is pending, then to patent it in the other country. So is there any threshold, or would you suggest that someone maybe, I'm not saying, okay, suggest to take a risk, but like what would you suggest is the minimal company size or revenue or, I don't know, export markets they're targeting that they should consider, and how much time they should put in the planning and getting the patents?
Vasco, it really depends on the industry. There is no company size limitation because there are even single inventors that file patent applications and get a granted patent that are not even a company. And there are also huge corporations that decide to keep their know-how as a trade secret and to not disclose it to anyone because, for example, a patent after 20 years will expire and your technology will become public good. While if you have a trade secret, you can keep it a secret for unlimited period of time, as long as you're able to keep it a secret. But it depends on how much you invest in R&D. Companies that heavily invest in R&D usually have patents because the cost of having a patent and the life cycle of a product is long enough so that the process of getting patent protection in their perspective of the time is not really a long time. Another thing is they're also aware that even from the time you get a patent pending, that's the moment when you file the application, you can already use this as an asset. There are very good case studies of companies that used patent pending application as an asset in negotiations, in contracts, etc. On another hand, if you have a product which has a short lifetime, for example, 6 months or a year, maybe it's not the smartest way to go with a patent. So it depends more on the how much you invest, what is the lifetime of your product, and what is the business vision you have for this product. Sorry, Vatka, I'm not hearing you.
We are talking about physical products. We are talking about manufacturing. Maybe before we go to software, because I know that that is your field and protection in software, in digital products, in digital rights, which is something that is at least new to many of us. Maybe like if I'm a service company and I provide services and I have packages of services, not I know whoever there is, what would be, let's say, because it's not a patent we are talking about, right? So what would be the protection that we can expect? Is there something we need to register, or do we need to have something in consideration? I don't know, copyright or whatever is. What's my option to protect my, let's say, author rights or my company's author rights as a service?
Well, from one hand side, the name, the logo, the slogan, trademark always applies. Doesn't matter what you sell. Trademark protection applies to anything that has a name on it, basically. When we have a software, we usually speak about copyright protection because copyright automatically protects the software from the moment it is created. Copyright protection extends for much longer period of time, and you don't need to register it formally in Europe. You get the protection from the moment you create the software. And that's what the type of protection actually software companies have immediately. But on the other hand, if the software also does some technical functionality, it can also be protected by patent. So what is the difference? When you have a copyright protection on a software, only this expression of the software as it is written is protected. While when you have a patent protection on certain functionalities on a software, the core functionality is protected, no matter how you write it in software. So patent definitely is a stronger protection. In the past, this was a big issue for software companies. Do you know who was actually the biggest lobbyist pro copyright in US in the past?
No, not
It
sure.
was Microsoft, because they used to sell their software on a disk. And piracy was a huge issue in the 90s and 2000s with the internet and the spread of information everywhere. So in 1998, when they voted the Digital Millennium Copyright Act, one of the biggest lobbyists for these protections to be actually available for companies was Microsoft. We had an issue at that period of time of piracy versions of software. It was illegally copied and distributed through illegal channels. So they made certain limitations what a marketplace should have in order not to be liable for infringing content that sellers sell and things like that. Now we have similar issues because we are in the era of AI, and now we will have different acts to see how we will handle copyright in this new age. This was a big issue at that period of time. Why it's not a big issue now? Because companies don't sell their software on a disk. They don't sell their software at all. They sell services to use the software. They sell software as a service.
Well, I do have two questions here now. I mean, even more. So now we're coming in the age of AI, and that is one aspect I want to cover, because you said there are some acts which are actual, some practices which are all new. But my question here is, now we had Microsoft and the pirate of the software, but we do have a lot of, now everything is in the cloud. We have a lot of no code programming and software development. So in that case, did I get you right? You're protecting the service you're providing, not the software, or there are combinations here? Because I don't like how to go further. I know a lot of companies that have, Katerina, they have their own software solutions, but they didn't code them. They use GitHub, they used open source, they interconnected different softwares and provided a solution. So in that case, what is the protection?
A very important part when they use third-party softwares, a very careful audit due diligence should be done to see if you're actually allowed, if you use third-party codes for right licenses, and to see if you're compliant with everything that you need to be in order to use someone else's software. The software is protected by copyright now as well, but the point that they don't share the software as they used to share is different today. So what is important that they pay attention to is licensing, under which terms they actually allow others to use their software. So there are open source licenses, there are closed licenses, which strictly define who can use under what terms. So what can they do? Can they sub-license and things like that? So software companies should pay a lot of attention on these things. There are a lot of licenses available. Each of them have different terms, and they should see which type of license fits the best for their business, let's say.
So what is that Creative Commons, for example?
It
Because
is a
there's
license.
EULA, Creative Commons, this and that. Can you maybe give us just an overview? I know it's probably, let's not go into too much details, but
yeah, let's say Creative Commons is a very common license that creators use. Today, there are different types of Creative Commons license where you can decide which type to use based on what you allow others to do with your content. Do you allow them freely to distribute the content, but always to mention, do you allow, maybe you don't allow them to distribute the content in any time. So there are different limitations, and people and companies should decide what is their business goal. Do you like someone to share your code or your presentation even, or your creative works, but always to mention you, or not distribute it at all? So they are kind of open source licenses where usually a payment is not involved, but it doesn't mean that everything is free. So open source is not always you can do everything with it. They should always look into the limitations of the license.
so if I'm a software engineer and I have my company of dedicated software engineers that we are focused on programming, who should we contact? Who should we go to understand these things? Should we go on a training or expect engineers to have it? Or maybe is there a checklist or step by step on how software companies or their employees can understand like what is to use, what is to mention, no matter what is the licensing type, who is responsible in software companies like that? I'm asking this because there are a lot of software companies, or let's say digital companies, coming up lately and growing. So, and I'm not sure in the smaller ones, especially in startups, how many of them are aware of the, let's say, open source. So we take it and we use it free, and they might have a kickback later on if they scale, right? Or I'm wrong?
Yes, you're right. You're not wrong. The point is that even if you use an open source software, sometimes what companies do, they actually pack the open source part of the software into their software and then license it under closed terms. And this open source part of the software is licensed under a license that does not allow this. So you're not allowed in any way to get paid for it. And that's very important to be aware of all of these things. The structured framework for doing this is a detailed IP audit or IP due diligence, because it is very important to establish the ownership of the things. Who is the owner of what? And that's very important in collaborations as well. I have my IP, you have your IP, but together we have a third IP. So sometimes for founders, it's inconvenient to speak at the beginning about ownership issues and questions like that, but it's always better to open them at start. So this IP due diligence process is a framework that will answer a lot of questions and will end up with workable action points how to structure the product, the software products, and to have a very clear picture. We're good with this, but we're not really good with this. Maybe we need to change this to avoid potential issues in the future. It is also very important to look into clauses, contracts with employees, the IP in which employees contribute while they work in the company, and what happens if they have some trade secrets and they take them with them after they leave the company. This is a huge framework, but it is step by step. It gives a structure and it answers concrete questions at the end.
So, short question: who conducts IP due diligence?
We do conduct detailed IP due diligence. Their
Cool.
company like ours, it is something that is a framework and which is very useful, especially for software companies. For any company, I would say, but here in software, we have a lot of intertwined open source, closed source licenses, and someone needs to clear the picture there.
It is. I mean, I'm on the side, not relevant to this, but working as a mentor to go to market and exports of software companies and so forth. And I'm sometimes involved in their investments. And often the question from investors, whether it's a VC, whether it's a business angel, whether whatever type of investor comes in, asks who owns the intellectual property. And in this sense, I mean, there are so many aspects, and I know that there is the goodwill or the difference between the assets and what they are ready to pay, which is probably equal to the intellectual property, to the intangible property. But what would you say are the key elements that investors look at, like in an intellectual property perspective, and evaluate, like what are the key elements in a software company, for example?
They would always look for registered IP rights to see if you have some registered IP rights. I believe they usually start from there, but they will also look into the whole know-how that comprises the whole set of intangible assets a company has. They will look if they have well-established trade secret procedures within the company, if a trade secret is well documented, if it's very clear who has access to it, who does not have access to it, and things like that. They will look at ownership of different third-party softwares. If they use that legally, they will look in any type of ownership, basically. And investors do love IP. I always say that because IP predicts how long a company will last. If you don't have a protected IP and you go on the market, and if you're good at what you're doing and customers are willing to pay for your product, eventually someone will try to copy you. And then you cannot last for a long time because you will fight on a lower prices. When you have IP, you definitely can defend yourself.
Thanks for this. Let's go back to exports now a little bit. Because we're talking about exports. We are not going to go into details in contracts. Maybe I know that there is intellectual property in international contracts. So I would ask, like, when entering an international trade agreement or partnership, are there any specific IP clauses that companies should insist to protect their know-how or the proprietary information or from misuse or, I don't know, unauthorized sharing so are there any such key IP
Yes.
to think about to include in international trade agreements and partnerships?
Yes, there are. So there are certain parts that such agreements should have. There are different types of agreements. For example, you can have a company that has a factory in Macedonia and produces here and exports only sales through distribution channels in other markets. But you could also have a company that manufactures in a different country under a license and then sells from there. So each contract should have a clear ownership clause. So who owns what? Then it should have a clear licensing clause. What can I do with this type of ownership? And it should also have, this is something that I've seen very companies omit in the contracts, quality control clause. So what is the quality that you expect from your product? How do you expect this whole chain to close up until the moment the product goes in the hands of the end customer? And this is especially very important in cases when, for example, you make a contract with a factory in another country to produce your goods there and they'll sell them from there. You have to have a very, very strict quality control clauses, because if they output a product that will have your name on it, they have to be associated with a certain standards and with a certain levels. And this is very important for companies that companies usually associate. I will connect this with trademarks. Trademarks with a defensive role. For example, I can defend myself if someone copies me with my trademark, but they rarely see the trademark as a proactive tool for revenue generation or for quality control. You can also franchise your trademark, and you can define a strict quality control rules that your trademark, anyone that will buy the trademark, that needs to comply with. This is very interesting and different perspective when you look in your IP rights, because their business purpose is much broader than only defensive. Even though the defensive and the blocking role is the first one, and we usually speak about that, this licensing part opens a completely new field of opportunities for revenue for companies. And it is the same with patents. There are companies that have their patents on very specific technologies, but they don't have the money to invest in a factory and to start producing and manufacturing it here in Macedonia. So they sell the technology, they sell the know-how, they sell their intellectual property, they license it. They can transfer it completely, but they can also license it. And someone else that can invest, that has the investment, the money, can produce it there.
Great. I mean, now you've opened up several aspects. I wanted to ask you about the key aspects in what to consider when working with distributors and going to markets, franchising. But maybe for franchising, like what are the minimal requirements that a company that wants to franchise should protect before doing the franchise? What you need to protect with an institution and what is given, like copyright, you don't need to protect, it's protected, right?
Yeah.
Did I get that right or no?
Yes, we don't register copyright. Only in US, there is a governmental body for registration, which is required when you enforce the copyright. But you have the protection from the day of creation.
Maybe, so let's come back to franchising. For me, it's new. I mean, I'm working with a company now developing a franchising system. So, but we didn't go into these details. We were doing the business aspect of it. So what is the minimal protection requirements they would need to set in place before they search for franchisees?
Vasco, I don't think that companies should make their decision about protection in order to sell a franchise. We go again back to their unique value proposition. They should protect what really brings value to their company, because at the end of the day, people will pay for that valuable part of the franchise. We always go back to this question at the beginning. What are your customers paying you for? Okay, this, and this. Is this protected? Can we protect this? What else can we do? And then when you pack everything, you usually have a trademark. This is something that is the name that people recognize you for, and they connect the origin of the goods with this name. There are patents sometimes in manufacturing, especially process of manufacturing a product or a certain functionality of a product. And there is always a valuable know-how. And this is the trickiest part, I would say, because when we speak about trade secrets, companies should always look for options where they need to share as little information as possible, because the value of the trade secret is higher when less people know it.
Shortly. I mean, trade secrets, when we are not informed, we often see them as something an information that I keep for myself. But maybe let's define trade secret for us in a business sense, or what it means for intellectual property. I don't know if or maybe give an example from that perspective.
Yes. The trade secret is basically something that you keep secret. Of course, you don't register it anywhere because you keep secret inside of the company. There are certain rules that need to be satisfied for a trade secret. It has to be well documented. There should be strict rules who has access to it and what happens when they access the trade secrets. I will give you an example. For example, in pharmaceutical companies, you have patents that protect the product. And you have, let's say, 5 patents that protect 5 aspects of one product. And when you take these 5 patents and put them in front of yourself, you feel that something is missing for you to be able to produce this product. And usually, in order to be able to produce everything, there is some valuable know-how that companies, of course, don't patent. Sometimes because it's not patentable, but sometimes on purpose. Because only when you have this secret ingredient, you can actually produce the same product. That's sometimes part of the manufacturing process, how to make it more efficiently, how to make it better. It's different in any industry, but there is always some secret sauce to making a product stand out. And this is the part that actually they need to produce the product as we see it on the market. And that's a trade secret. They should be very careful with trade secrets, as I said, because the more people know about it, the more vulnerable it becomes. And they should have very strict procedures for this. It is also very tricky how to share it with potential investors. You don't want to share it. You usually share the processes and the procedures you have inside your company to protect the trade secret, because that's the value of it.
Focusing on SMEs, on small and medium enterprises, like what would be the minimal, non-negotiable IP requirements? I know you mentioned it, but maybe summarize it. The checklist as a checklist that a small and medium-sized company should have prior to exporting technology or goods for the first time.
Well, three things I would say. I always recommend before making such a step, like going to another market, knowing first what you own and doing IP due diligence to be precise on what you really own and what is yours, and to have it clear in your mind, to have a clear picture what is your starting point. Then looking into the markets where you want to expand, what is already registered there to avoid any possible conflicts. And the third part would be, okay, what I need to register. Once I know step 1 and step 2, what do I need to register to go with an insurance on that market?
Where can small and medium enterprises managers and owners turn for reliable and cost-effective IP advisory and educational resources to help them navigate all these different types of IP they need?
One of our roles as a company, we do this on a daily basis. We do advise small and medium enterprises and inventors in general how to effectively protect and also commercialize their IP. Our point of view is not only from the legal framework, but also from a business framework. We always try to tie a business goal to an IP asset and try to make people see the value that their business really can get from that asset. Because it's not the point only to register, but to get a business value and a return of investment from that assets. It is very interesting perspective to think about if you take marketing, for example, out of your company, what would the impact be on your business? And people usually see that very clearly, but IP is really intangible, the intangible part that connects things. And when we ask them, if we take IP out of your company, what will the impact be? They usually start to think of the valuable intangible stuff that they actually have, but they haven't structured. So we do that kind of advisory for companies, and we also do local and global registrations for every industrial property right, such as patents, trademarks, and industrial designs as well.
So because this podcast is not meant to be localized, so where do you operate? Which countries, like SMEs from which countries can come turn to you?
We are based in Macedonia, but we operate globally. We have partner firms basically everywhere in not only Europe, but in US and in Asia. IP rights are national rights, are territorial rights. And in many regions, local IP attorneys are required. And we have this network of collaborators basically all over the world.
Katerina, I know you have helped or contributed to more than 250 US patent litigation cases in the past. So I think that just for the listeners to know who they have been listening to so far, if they came to this end. So for the end, I do want to ask you just one question. I mean, I have so many, but this is the time you have available. So if you could leave the listeners with just one single takeaway about integrating intellectual property into their global growth plans, into their export, into their business paths, what would that advice be?
Well, don't underestimate the intellectual assets that you already have, but structure them and sell them as you should be sold on the global markets. If you allow me, I will add something additionally. It is the intangible tool that actually does not require the physical stuff to transport down. You can pack it in a certain IP right legal package, and you can sell it literally worldwide. And I encourage everyone to recognize their IP assets first and to collaborate with specialists that can help them to sell them literally worldwide.
So many questions raised in my head now, like what about digital products? What about distributors, rights, territories? But for that, at another time, thank you for being with us and for recording this episode. And I hope that people find a lot of information. This will be available and they can contact you if they need intellectual property in the future. Thank you, Katerina. And this has been the Experts Insights podcast. Follow us on YouTube, Amazon, Apple Podcasts, and Spotify.